হ্যালো বন্ধুরা, ওয়েলকাম টু ম্যাথ গুরু। আজকে কলকাতা হাইকোর্টে 32,000 টিচার যা চাকরি বাতিল করা হয়েছে সিঙ্গেল বেঞ্চ থেকে, সেই নিয়ে ডাবল বেঞ্চে একটা মামলা হেয়ারিং হয়েছে। কিন্তু তার মধ্যে ট্রেন আনট্রেন নিয়ে একটা আর্গুমেন্ট করেছে গভর্নমেন্ট। সেই আর্গুমেন্টটাকে আগে আপনারা দেখুন, তারপরে কি কি আলোচনা হয়েছে এই আর্গুমেন্টে, আর কী করে এটা নিওস ডি.এল.এড পক্ষে একটা বড় আপডেট আছে সেটা আমি আপনাদেরকে এই ভিডিও লাস্টে জানাবো। আগে আপনারা ভিডিওটা ভালো করে দেখুন।
May I just continue this paragraph? It was published on 4th of list of 8th. From the dates and the list, it is clear that all trained candidates of TET 2014 were appointed through the first list, and after completion of the same, as per notification dated 2nd March, to the board appointed non-trained candidates. So they were also aware of the appointment of non-trained candidates. That is more evident from the 11. Your petitioner states that on 23rd, now they are trying to explain the delay or something like. Your petitioner states that on 23rd December 2020, 15 February 2021, 17 February 2000, notices were published for recruitment as assistant teacher in private skill from TET 2014. The board has appointed non-trained teachers after 2016, even and intentionally ignored the petitioner by giving excuses of notification issued by MHRD by such and such. This, again, I am saying that was the case made out that after 31st March 2016, no appointment. Thousands of non-trained students were appointed and petitioners, though similarly placed, were ignored. If it is stated, if it is a stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law.
What did they mean by that? If it is the
They
standard,
said that after March 2016, no non-trained candidate could have been appointed because the MHID notification, that is the cutoff date. So, but the board had given appointment to the non-trained candidates beyond 31st March, so they should be given appointment.
where is that notification
Yes,
of
Malad.
August 2017?
Compilation.
Page?
My lord, I have given another compilation, that is list of events. Kindly take. I'll not show any. All documents have been given, including the learned judge, the order of the Honorable Justice Karnan extending that, my lord, selection. And straight away come to, my lord.
Karnan's order is page 63.
Debo, Baba, stop Debo. Has you got it?
Page?
Alright, page is, my lord, the page, kindly take 103.
No, Mr. Bandyopadhyay, even if this point is not taken, suppose extension, assumingly it was till 31st of March 2016.
Even then the writ was not maintainable. That is why I am saying.
Let us 31st March 2016 was the date for completion of that qualification. Relaxation given up to 30. Now the employment recruitment rule was of 2nd March 2016. So this point, I don't know what they will be arguing. Is it their case that since the relaxation period has expired, no appointment could have been made of untrained candidates?
Again, come back to page paragraph 11.
No, this is one aspect of the matter. And the other is, suppose you do not consider August 2016. If we take, if up to extension was up to 31st. Since the selection process commenced prior, recruitment rules were framed prior to that. Then whether this relaxation will still apply after the board has published commenced the selection process?
Yes, because this is the mandatory qualifications, my lord, as per the under the Right to Education Act.
That is why 3-2 proviso was given, that once you are appointed, you can complete this.
See, my lord, that
I think I'm not clear to you.
So far as the untrained candidates is concerned, there was a time period given under that particular notification.
আচ্ছা দেখি আমি
Your
Which
lordship
page?
kindly first take that first notification.
Page that is page 95
MHID.
MHR.
Yes, that your lordship has got it. Now
not-
kindly take one judgment.
আবার যা আগে মেমোটা দেখি
Not judgment. This is sequence. This was sequence of event. Kandaneta কোথায়?
Page 63.
Page 63. Kindly take page 63. By that time, no extension came. 14th of September 2016. Page 63.
yes what is this
Kindly state the operating portions. I am not. But Mr. Shubhi Sharnal was appearing at that time.
no this by this extension was given by the
Yes,
court.
by the court till the extension is obtained from the central government, from the ministry. Kindly take page. Page 73. Kindly come to page 73.
Yes.
Bottom. It will make the position clear. From the above deliberations, the views of the court are as follows. May I?
Yes.
The state government sought relaxations from the second respondent herein, namely the Ministry of Human Resource Development and the School Education Literacy Department under the provisions of Section 23(2) of the Right of Children to Free and Compulsory Education Act 2009. The rules framed thereunder in order to fill up the entire vacancies with the untrained candidates, since there are no adequately trained candidates who are presently available. The sixth respondent had granted relaxations after certain conditions. Similarly, the trained and untrained candidates shall be appointed to the available vacancy, as the trained candidates will not be prejudiced in any manner. The state government took the stand in order to provide proper educations to the students who are in poor need of the same in the entire state. Education is a fundamental right to the state. The learned additional advocate general rightly pointed out that approximately 40,000 vacancies are available as of now. The sixth respondent's condition that the state government is to first absorb and appoint the trained candidates and thereafter appoint the untrained candidates. The trained candidates, as per the statistics by the learned additional advocate general, are about 19,495. Therefore, the untrained candidates' appointments will not be disturbed with the trained candidates. All the respondents are strictly to follow the logical use as per provisions of Section 23(2) of the Right to Chair. The notification dated 1st of April 2015 granted an extension of the relaxation up to 31st of March 2016. But due to the General State Assembly elections, the appointment process has been kept in abeyance. As such, there is no lack of service on the side of the state government of West Bengal. Therefore, this court permits the respondent number 1, 2, 3 to proceed in the mode of selection for appointment of teachers. Further, respondents are liberty to approach the respondent number 4, 5, and 6 in order to extend the relaxation.
Where is that 4th August? Up to
Yes,
August.
now that August you will file 103, page 103.
Page 103.
Is it legible, Malad?
Even then we have to read. Yes, page 103.
Yes, it is of National Council of Teacher Education, Malad, notification dated 22nd September 2017. This notification was not there, Malad, in the first compilation placed by our senior friend Mr. Kullan Bandobadhyay.
No, this is of NCT.
NCT, Malad, I am coming, Malad. This is
Page 95 is of Ministry of Human Resource Development.
yes,
Extension
no, Malad, both, Malad.
MHRD.
Yes, MHID and Malad. Under the same, I will show the relevant portion.
Central government has to relax, not NCT.
Under the specific Malad, provisions of the Right to Children and Free Education Act, this notification was also issued.
Kindly come to page 95. This is of central government did have the authority in consultation with the council, maybe. Page 95 of Priyanka.
The MHID notification. Yes, kindly
Has
take.
there been any MHRD notification?
Yes, Malad, that has been referred to in this. Malad, that is why.
Sure.
And whereas, Malad, last and whereas,
Huh?
in view of the above mentioned directions of the Ministry of Human Resource Development under Section 29 of the NCT Act, and after considering the recommendations of the expert committee chairperson in NCT in exercise of his power under clause 12 of the NCT recognition of norms and procedural regulation 2014, granted relaxation by the NCT headquarters such and such and later to the following provisions in the NCT regulations 2014 for ensuring that the directives of the MHRD for implementing the amendment to RT Act 2009 are duly fulfilled. Then, Malad, kindly skip this 1 to 4.
Yes.
Then, Malad, next page 104. This 104. And whereas, Malad, I'm just skipping the first part. And whereas,
Yes.
after having considered all the above facts and figures, the NRC considered the case in its 275, decided that the recognitions be granted to the National Institute of Open Schooling for D.El.Ed again scheme, that is for the D.El.Ed training. That is meant for training to the untrained candidate. Next page, 105, serial number, Roman 8.
18. Yes, read that this program shall.
This program shall only be for those in service, untrained teachers in the private unaided schools appointed on or before government aided and private unaided schools appointed on or before 10th of August 2017.
This program, program is pertaining to
D.El.Ed, that is the training qualifications. That is to be obtained by the all teachers, as per all untrained teachers. NCT regulations, the D.El.Ed to be obtained, and in fact, the 2024 judgments cited most probably by Pratik Dhar, that refers to this. So, up to 10th of August, there was no other relaxation. But after 10th of August, there was no scope of appointing any untrained candidates. And no appointment in the present case has been made after 10th of August.
Yes.
That is the cut-off date. So now they were aware. They didn't say it because they said that 31st March 2016 is the cut-off date. Even then, on their own pleading, the writ was not maintainable in 2022 because no appointment could be made. Because there is no negative equality. That one wrong has been committed, so they should be given the. Just come back to page 104. One explanation probably that may confuse your lordship subsequently. That is why. Page 104, serial number 4. After the whereas, serial number 4. Just mark it, NIOS shall operate study centers manned by staff by academy as per instructions of NHRD to enable NIOS to complete the training of in-service untrained teachers numbering out 11 lakhs by 31st of March 2019 all over India. And that is why this 18th month, instead of 2 years, that was relaxed, reduced to 18th months, which have been subsequently approved by the Honorable Supreme Court in 2024 judgment. May I clear? Because requirement was 2 years. Because of this decision that one must have this training by 31st March of 2019. Now 10th August was the cutoff date, so they are not getting this 24 months. They were only getting 18 months of training. So for those teachers, it was relaxed, and ultimately which has been approved by the Honorable Supreme Court, relied upon by Mr. Pratik Dhar repeatedly. Page 104.
Yes.
Now kindly again come back to page 39 of the paper book, paragraph 11 I have made. That is their case. After March 2016, the appointments are bad in law. How could you file these writ petitions in September 2022? You are asking to be further wrong to be committed. It was your belief. Now what they are shifting. This was their individual case. They saying now what legal right they had on that date.
Yes.
This is a fundamental of mandamus, that one has to have some either fundamental right or legal right breached. What legal right they had in September 2022? After 31st March 2016, when they are themselves, their cases after 31st March 2016, no appointment. Have you approached the court before 31st March 2016?
আশা করছি আপনারা ভিডিওটা পুরো দেখেছেন, যেখানে গভর্নমেন্ট সব কিছু জানে কি কী করে 2016 সালে অবধি ট্রেনিং যা একটা কম্পালসারি ছিল সেটাকে গভর্নমেন্ট নিজেই MHRDকে লেটার লিখে সেই লাস্ট ডেটকে স্ট্যান্ড করিয়েছিল। তারপরে যত প্রাইভেট, ওখানে অ্যাডভোকেট বাবু পরিষ্কারভাবে মেনশন করেছে কি গভর্নমেন্ট অ্যাডেড প্রাইভেট স্কুলে যত আনট্রেন্ড টিচার ছিল তাদেরকে NIS থেকে D.El.Ed ডিগ্রিটা কমপ্লিট করানো হয়েছিল। রিজনটা এই কোর্সটা 18 মান্থ কেন আছে সেইটাও উনি জানিয়েছে, কারণটা আমাদের গভর্নমেন্ট হাতে সময়টা ছিল না। 31 মার্চ 2019 অবধি লাস্ট টাইম ছিল, তাই জন্য এই কোর্সটাকে 24 মাস না করে 18 মাস করা হয়েছিল। কিন্তু যেরকম নর্মাল D.El.Ed একটা কোর্স সেরকমই এই পুরো কোর্সটা করানো হয়েছে। তারপরে গভর্নমেন্ট নিজেই এখানে বলছে কি যত প্রাইভেট স্কুলের টিচার ছিল ওরাও এই কোর্সটাকে করেছে। কিন্তু আজকে যখন আমরা ডকুমেন্ট ভেরিফিকেশনে যাচ্ছি সেই সময় গভর্নমেন্টে একটা আলাদা স্ট্যান্ড, সেখানে নানা রকম ডকুমেন্ট চাওয়া হচ্ছে ডকুমেন্ট ভেরিফিকেশন নামে। কিন্তু যখন আজকে কলকাতা হাইকোর্টে গভর্নমেন্ট নিজেই সাবমিশন দিচ্ছে, উনি নিজেই অ্যাকসেপ্ট করছে কি যারা NIS থেকে D.El.Ed করেছিল গভর্নমেন্ট নাহলে প্রাইভেট স্কুল প্রত্যেকটা একটা টিচার ছিল। কিন্তু আজকে এই যখন ডকুমেন্ট ভেরিফিকেশন হচ্ছে আমাদের সেই সময় একটা আলাদা স্ট্যান্ড পরিষদ আর ওয়েস্ট বেঙ্গল গভর্নমেন্ট কেন নিচ্ছে আমরা বুঝতে পারছি না। তো আশা করছি আপনারা নিজেই বুঝতে পারছেন কী করে একটা ডাবল স্ট্যান্ডার্ড শো করা হচ্ছে NIS D.El.Ed ক্যান্ডিডেটদের জন্য। কি রুল দিয়ে কোন রুলটাকে ফলো করে আমাদেরকে রিল্যাক্সেশন দেওয়া হয়েছিল, কোনটা রুলটাকে ফলো করে আমাদের ওয়েস্ট বেঙ্গলে এক্সটেনশন নেওয়া হয়েছিল যা মিনিমাম রিকোয়ারমেন্ট আছে প্রাইমারি টিচার জন্য, সব কিছু ওখানে পরিষ্কারভাবে জাস্ট অ্যাডভোকেট বাবু নিজেই বলেছে। প্রত্যেকটা রুলে উনি সেকশনটা জানিয়েছে, রুলটা কোন নিয়ম অনুসারে এই এক্সটেনশনটা দেওয়া হয়েছে সব কিছু উনি নিজেই জানিয়েছে। কিন্তু তারপরেও যখন আমাদের ডকুমেন্ট ভেরিফিকেশন হচ্ছে আমাদেরকে একটা হ্যারাসমেন্ট করা হচ্ছে। আশা করছি আগামী 5 তারিখে যখন সুপ্রিম কোর্টে আমাদের কেসটা উঠবে, জাজ সাহেব এই মামলাটাকে একটু ভালো করে দেখে আমাদের পক্ষে কিছু না কিছু একটা অর্ডারটা দেবেন। নিশ্চয়ই 5 তারিখে কোনো অর্ডারটা হবে না, কিন্তু এই মামলাটাকে উনি ওপেন কোর্টে শুনবে কি শুনবে না সেইটা আমরা 5 তারিখে ক্লিয়ার হয়ে যাবে। তো 5 তারিখ অবধি আপনারা ওয়েট করুন। কিন্তু এই ভিডিওটা আপনারা ভালো করে দেখুন, প্রত্যেকটা গ্রুপে শেয়ার করুন কি কী করে ওয়েস্ট বেঙ্গল গভর্নমেন্ট NIS D.El.Ed জন্য একটা ডাবল স্ট্যান্ডার্ডটা মেনটেন করছে। এর মাঝখানে কিছু নতুন আপডেট আসলে আমি আপনাদেরকে দিয়ে দেবো। চ্যানেলে নতুন থাকলে চ্যানেলকে সাবস্ক্রাইব করুন। থ্যাংক ইউ।